complainant's depositions and argue both at the same time.
Let's go ahead and do this just now. I think I'd rather separate that and then do the other. Do you need some water or something?
I don't know which ones they're arguing about, which ones they're talking about, which ones we may decide, or decide to try the case, what we might offer. I mean, it's up to us to prove that it's not hearsay. So I think.
What I'd like to do right now, with a little bit of time we have this morning, is to see how we are, just a status report on a very involved trial where we had to move it to another location. And so with that in mind, can I get any kind of update trial on February 2nd? From the state?
Yes, ma'am. A couple of things, 3 things mainly. We have in our possession. Our timeline to get 3914B in is Wednesday or Tuesday, I believe, the 13th.
The status? Nothing that you can see that would delay us from trial on February 2nd.
And of course, the other issue.
Yeah.
On the, yes.
Okay, first of all, name and spell it, Rob.
Rob Freyer, Freyer, Assistant DA.
Tell me what purpose was it here today?
The defense filed a couple motions in regards to some pretrial matters that I really can't go into very much about some statements that parties to the case gave in anticipation of litigation down the line. Obviously we're here, the defendant was taken into custody. I cannot really verify or deny whether or not he gave a statement, but there are certain pretrial matters, especially on a case that's as serious as this. Sometimes issues need to be flushed out or litigated prior to presenting the case in front of a jury because it can affect appellate issues. There's certain things the defense has to do to preserve error in the event the defendant's convicted, and strategy-wise in terms of how Mr. Brumberger, Mr. Blackburn, and I put this case together. It is a very involved case. It is a very detailed case. I've never seen, other than maybe a couple of aggregate theft cases that I've worked on, I've never seen a case with this many potential witnesses in my life.
How many potential witnesses are we talking?
90, potentially. That's potentially. That's not definitively. Trust me. I know that it's very difficult for jurors to serve and take off, weeks and weeks and even longer at a time. So we do not intend on calling a fraction of those.
And we're not even talking in Montgomery County. We're talking change of venue.
We are trying this case in Galveston County. It's my understanding that Judge Hamilton has conferred with the court staff and the administrators down there, and we got a panel of 200 people coming over on February the 2nd, day after the Super Bowl, I think.
And start trying to get a jury pool put together. You think that 200 is enough in there, or?
Well, I mean, obviously, this case has received so much attention that I would be disingenuous to try to hide the fact that the allegations in the indictment, which is public record, are horrific in and of themselves. And obviously there's been a passage of time from when this event happened and to when the complainant passed away. All that was flushed out in open court during the certification hearing that Mr. Brumberger and Amanda Hill with the county attorney's office ably handled back in March of last year.
So the motion that the judge heard today that we'll be deciding on Monday, what did that basically
The defense filed, back in December, we weren't able to get it done, but the defense filed 2 motions to suppress, basically, for lack of a better word, 2 motions to have evidence that might come in thrown out or not admitted or deemed inadmissible and not allowed to be heard by a jury for various legal issues, whatever they may be.
They seem like they're really set on this deal with the office where he was interviewed. Why was there so much emphasis put on this office where he was interviewed?
Well, juvenile law in the family code, which covers juvenile law and the taking of in a hypothetical sense, the taking of an in custody statement, the rules are very, very different than they are in adult court. So they're just different, and the legislature has factored in, I guess, rationale with the age and the sophistication of the defendant. He's a defendant now. He ain't a child. But he was back when he committed this offense. So, child is a legal term of art, which means any individual under the age of 17, which is, at that point, once you hit 17, you're subjected to the jurisdiction of an adult district court or county court.
Now we're talking current law compared to old law. This would have fallen under the old law back then in the 90s.
Yes.
98.
Yes.
Okay.
Yes.
All right. How hard is this case to try, being this old and this much detail, and you no longer have a victim here, but you have a dying declaration?
Well, our evidence intends to touch on some of those issues, and I guess if the court wants to look at, or if the public wants to look at, anybody interested out there in the public wants to look at the clerk's file, I think it's a matter of public record, some of the things that were filed. So there are certain exceptions to the hearsay rule which could highly possibly be implicated here. So,
How long do you figure a trial like this could take?
a long time. Longer than your standard 4-day dope case or aggravated robbery. It's gonna be a tough case. It's
Would
gonna
it
be
be
a long
weeks, a week, or
I don't
10
know.
days?
You never know.
Never.
Judge Hamilton, I've tried a number of cases in front of her, and once you get going, and she's very, very efficient and professional, and she's thorough to the point where, she doesn't let attorneys just talk and beat a dead horse. She likes to have the proceedings move along in an orderly fashion, based upon what I talked about with you, Scott, a few minutes ago. The witnesses' schedules, work schedules, school, the hike. It's 100 miles to Galveston from here. The officers, when an officer's testifying in court, he's not working on all the other cases that he has still sitting on his desk. Then the jurors that are going to serve in this case. There's going to probably be 12 jurors, and my guess 2 to 3 alternates. Because Judge Hamilton is all about being efficient and professional.
All right.
Okay, first of all, name and spell it.
Tay Bond, capital E, period, capital T-A-Y, last name Bond, B-O-N-D.
All right, tell me today's proceedings. Tell me a little bit about it and what you're expecting and what you're looking for.
What we're doing today is trying to get a ruling from the...
Okay, what are you doing today now?
One of the well-known problems with this case is that the interview was not done in accordance with the law at that time as it pertains to juveniles. And we're trying to get the judge to rule on that fact. It was a problem back then. It's almost entirely detrimental to their case, and it will be again.
What is the deal on, a selected room? You've got several rooms in the sheriff's office there, and there's one specific room, and there's a lot of emphasis being put on this. What is it?
The legislature is the one that came up with the rule that you have to designate, and it has to be approved, a specific room that you can only interrogate juveniles in. We're not talking about dealing with adults. We're talking about a specialized class, which is children.
And this room was not designated as such?
No, Montgomery County had not designated a specific juvenile processing office, and they knew it back then. I believe that they know it today. They just didn't come forward and say it specifically, but it's fatal to their case.
So what could actually happen if the testimony given in that room was not basically it was not legal? What could actually happen?
Well, they just would not be able to use any of the evidence that was obtained, but the evidence that was obtained is really not material because my client never implicated himself in a murder. So we're arguing, making sure that the record is protected, making sure that the law is followed, and just simply trying to do what law enforcement and the county attorney and the district attorney already knows, is that that statement was taken in violation of my client's rights.
Trial coming up, first week February? What are you looking at there?
First week of February, we're going to be down in Galveston. They've provided us some pretty good courtroom settings to get the case tried. We're going to try it as quickly and efficiently and fairly as possible.
How long do you think something like this would take?
I would like to believe that the state can present all the evidence that they need within a couple of days, 3 or 4 days, because there actually is no evidence in this case. It is all innuendo and hearsay. There is no new evidence from back when my client was 13 years old until now.
So basically, Judge, what she's ruling on today is just on that room, whether that room was basically used and whether that statement could be used?
Well, the way that the law reads, if the room was in fact not properly designated, then anything that came out of that room would not be admissible. So the client's statements, the client's written statements would not be admissible at trial.